Have you ever watched 19 state governments all scramble at the exact same moment because of a single court decision? Because that is precisely what is happening right now. A Supreme Court ruling delivered by a unanimous 9-0 vote has sent shockwaves from the marble steps of the nation's highest court straight into the legislative chambers of the most restrictive gun law states in America. And in an era defined by a deeply divided nation and an equally divided court, something truly unprecedented just happened. The justices came together in a rare moment of absolute unanimity. And in doing so, they didn't just tweak a law around the edges. They fundamentally dismantled a legal architecture that has governed firearm ownership and carry rights in the United States for over a century. You've seen the headlines. You've seen words like panic, shake-up, and historic flashing across your screen. But right now, there is one question I want you to hold on to for the entire video, and I genuinely want your honest answer in the comments when you're done watching. Is the elimination of permitting requirements, mandatory training, and waiting periods a victory for constitutional freedom, or does the disappearance of those safeguards make your community less safe? Drop your real thoughts below. Not what you think people want to hear, your genuine reaction. I read far more comments than you might expect. Now let's cut through the noise and talk about what actually just happened. Most Supreme Court decisions involving firearms are close, 5-4, 6-3. A unanimous 9-0 ruling is different. When every single justice reaches the same conclusion on a constitutional issue, it sends a message that lower courts and state governments simply cannot ignore. That is why legal analysts across the country are calling this one of the most significant developments in the history of Second Amendment jurisprudence. For the last several years, since the landmark decision in New York State Rifle and Pistol Association versus Bruin, America has been living in a state of legal limbo. Lower courts were confused. Legislators in restrictive states were furious. Gun owners were caught in the whiplash of conflicting rulings. One day a law stood. The next day it was struck down. But this new unanimous ruling changes the game entirely. For the first time in living memory, the court has applied strict scrutiny to the Second Amendment. Think carefully about what that means. Strict scrutiny is the highest bar in constitutional law. It is the same demanding standard reserved for fundamental rights like free speech or the right to vote. Under strict scrutiny, a government restriction doesn't just have to sound like a good idea. It must be proven absolutely essential to public safety and the least restrictive way possible to achieve that goal. Historically, many lower courts treated the Second Amendment like a second-class right, applying a much weaker intermediate scrutiny standard. If the government had any halfway decent reason to restrict guns, courts usually let it slide. That world is officially over. And here is the part most coverage is missing. The ruling itself is only half the story. The real story is what happens next. Because while the decision came from Washington, its consequences are now unfolding in state legislatures, governor's offices, and courtrooms across the entire nation. Let's break down the 5 major categories of gun laws that are collapsing right now one by one. The first is the death of may-issue permitting systems. In states like New York and New Jersey, officials had near total discretion over who could receive a concealed carry permit. You could pass a background check, complete training, and have a completely clean record. But if the local police chief or a judge decided you didn't have a good enough reason to defend yourself, your application was denied. The Supreme Court already dealt a significant blow to this system in Bruin, but many states dragged their feet or created workarounds. This unanimous ruling is the final hammer. It makes crystal clear that subjective government discretion has no place in the exercise of a constitutional right. If you are not a prohibited person, the state cannot invent reasons to keep you disarmed. Shall issue is now the law of the land, nationwide. The second category is the end of mandatory training requirements used as barriers. And let's be careful here, because nuance genuinely matters. The court did not say training is harmful. The justices acknowledged that responsible training is highly beneficial for gun owners. However, they ruled that governments cannot use mandatory, expensive, and often inaccessible training courses as a functional barrier to exercising a constitutional right. If a state demands you pay $400 to $600 for a specific approved course offered only twice a year in a distant city, that is no longer constitutional. It operates as a modern-day poll tax on your Second Amendment rights. Those laws are finished. Think about that comparison for a moment. You cannot require a permit to speak. You cannot charge a prohibitive fee to vote. The constitutional logic is now identical for the right to bear arms. The third category is waiting periods. The original logic sounded emotionally reasonable, a cooling-off period designed to prevent impulsive tragedies. But legally, this court ruled 9-0 that delaying the delivery of a lawfully purchased firearm imposes an unconstitutional burden on law-abiding citizens. Under the new strict scrutiny and historical tradition test, those waiting periods cannot stand. Courts are increasingly being asked not whether waiting periods are effective policy, but whether they are constitutional. And those are not always the same question. The fourth category is excessive fees. The era of 100, 200, or even higher application and permitting fees is over. The court made clear that fees must be nominal. If the cost is prohibitive for ordinary citizens, the law fails constitutional review. The principle is straightforward. If only wealthy Americans can realistically afford to exercise a constitutional right, then it is no longer truly a right. It has become a privilege. The fifth and perhaps most explosive category is the gutting of blanket-sensitive places restrictions. After Bruin, several states tried to designate nearly their entire territory as gun-free zones: public transit, parks, parking lots, libraries, restaurants, playgrounds, entertainment venues. The Supreme Court examined American history and said no. Historically, sensitive places were narrow and specific: courtrooms, legislative chambers, schools, not public buses, grocery stores, or city sidewalks. Those overly broad prohibitions are now largely unenforceable. You are already watching the scramble unfold in real time. Attorneys general in 19 of the most restrictive states are holding emergency meetings. Governors are issuing frantic statements. Legislators who built entire careers on tough gun control are suddenly facing a new reality. The legal foundation they relied on for decades has crumbled beneath a single unanimous decision. California, New York, New Jersey, Illinois, Hawaii, Maryland, Massachusetts, Connecticut, Delaware, Rhode Island, Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, and Virginia are all watching carefully constructed regulatory walls collapse. Imagine spending years building a complex legal structure, passing dozens of regulations, defending them in court, investing millions of taxpayer dollars to keep them in place, then waking up one morning to discover the foundation supporting all of it may have just been demolished. Take California specifically. Governor Newsom has already signaled he is exploring enhanced background check systems that go far beyond the federal standard. But here is the critical point. They can no longer stop the actual carry of firearms in most public spaces. The massive list of sensitive places that included parking lots, playgrounds, libraries, and public transit, largely dead after this ruling. Lawsuits are already flooding the courts demanding immediate injunctions. In New York, the Concealed Carry Improvement Act, the very law passed after Bruin specifically to preserve restrictions, is under heavy fire. Within hours of the unanimous decision, multiple federal lawsuits were filed targeting the bans on carrying in Times Square, subway stations, and places of worship. Legal experts tracking the situation say there is a very high probability that a federal judge will issue a preliminary injunction within the next 30 days, blocking enforcement of those provisions. Illinois and Chicago are feeling the pressure from multiple directions. The waiting period law is now on life support. Chicago is desperately attempting to pivot toward ghost gun bans and restrictions on three-dimensionally printed firearms, trying to exploit definitions that might survive the new scrutiny. But the days of forcing residents through expensive training and subjective good cause requirements are effectively over. Even Hawaii and Maryland are pivoting hard. Hawaii is already defending its private property carry bans in the Wolford versus Lopez case that legal analysts expect to reach the Supreme Court soon. After a 9-0 ruling, most observers believe the court will quickly strike down requirements for property owners to explicitly consent before someone can lawfully carry on their premises. Now here is where the story takes its most fascinating turn, and it is something almost nobody is covering properly. When courts limit one regulatory strategy, governments look for another. That is not unusual. It happens in every area of law: tax policy, speech regulations, property rights, privacy disputes. And it is happening right now with firearms. Expect a massive push for ammunition regulations, micro-stamping requirements, special serialization mandates, outright restrictions on certain types of ammunition sales. Some states are already exploring insurance mandates, requiring gun owners to carry liability insurance just to legally possess or carry a firearm. Others are strengthening red flag laws and dramatically expanding the definition of who qualifies as a dangerous person. If you have ever had a mental health evaluation, a contentious divorce, or even a heated social media post, you could potentially find yourself on one of these expanded lists. We are also likely to see aggressive laws around safe storage, not recommendations, but mandatory locked storage requirements with daily fines or criminal penalties. Cities may attempt to use civil liability ordinances to pressure private businesses into banning firearms on their property, making any business that permits lawful carry financially responsible if any incident occurs. The goal does not change, the method does. That is why many constitutional scholars believe the next decade of firearm litigation in America may look completely different from the last. And here is what makes that observation especially significant. The legal reasoning behind this unanimous decision could influence future cases far beyond the Second Amendment itself. Every Supreme Court decision sends signals, not just about the specific issue being decided, but about how the court views constitutional rights more generally. When the court adopts a strong position regarding government limitations on one right, attorneys immediately begin asking whether the same reasoning applies elsewhere. That is why constitutional law is often compared to a series of dominoes. One decision falls, then another, and eventually the effects reach places nobody initially anticipated. Let's talk about reciprocity, because this represents one of the biggest practical victories for gun owners across the country and one of the least discussed implications of this ruling. The principle is now firmly established. A constitutional right cannot be burdened simply by geography. If a state cannot impose excessive barriers on its own residents, it becomes dramatically harder for that state to refuse recognition of permits from other states. Your rights should not disappear the moment you cross a border. Driving from Texas through Colorado or from Florida up the East Coast just became significantly less of a legal minefield for law-abiding carriers. Now let's be intellectually honest about the tensions this ruling creates. The dissenting concurrences, even within a unanimous decision on the narrow licensing question, contained powerful warnings about real-world consequences. Justice Ketanji Brown Jackson was particularly direct, noting that the Bruin framework has already triggered a 455% increase in Second Amendment challenges and calling the analytical system unworkable in practice. She and others pointed out that America in 2026 is not America in 1791. We have over 330 million people, modern high-capacity firearms, and very different patterns of violence. Tying 21st century regulation exclusively to 18th century historical analogs, they argue, risks ignoring the practical realities of contemporary life. Justice Thomas, by contrast, believed the majority did not go far enough. He wanted to challenge background checks themselves in certain contexts. This tension reveals something important. This 9-0 ruling is not a simple victory lap for one side or a total defeat for the other. It is a jurisdictional earthquake. The Supreme Court has told states they cannot regulate the old way, but they have not provided a clear roadmap for the new way. That means every state legislature will now experiment. Some of those experiments will be struck down quickly. Others may survive, and the resulting wave of litigation could define American constitutional law for years. Let's bring this all the way back to your doorstep, because this is ultimately about real people, not legal abstractions. Think about a single mother working the night shift in Los Angeles. For years, carrying a firearm on her commute home on public transit could have meant a felony conviction. After this ruling, those blanket bans on carry in so many public spaces are likely unenforceable. She may finally have the legal ability to protect herself and her family. That is a real human consequence. Think about a small business owner closing up after dark in a high-crime neighborhood, or a retired veteran traveling across state lines who simply wants clarity about what is legal and what is not, or a parent worried about more firearms in more public spaces near schools. Those are the people who ultimately live with the consequences of these decisions. And right now there is a tremendous amount of uncertainty for all of them. What we can say with confidence is this: the legal landscape has fundamentally changed. The conversation has changed. The strategy on both sides has changed. And anyone promising you absolute certainty about every outcome is overselling their prediction. Constitutional changes rarely happen instantly. They unfold through litigation, appeals, injunctions, legislative responses, and court reviews. The process takes time, but here is what the facts confirm right now. May issue good cause permitting systems are constitutionally dead. Mandatory expensive training used as a barrier to entry is unconstitutional. Prohibitive application fees are gone. Overly broad sensitive places designations covering most of daily public life are unenforceable. Waiting periods for lawful purchases fail constitutional review. For those living in the 43 states that already had relatively permissive laws, this ruling acts as a powerful stabilizer and a strong affirmation that existing rights are on firm legal ground. For those in the 19 most restrictive states, the next 30 to 90 days are going to feel like legal whiplash. Expect emergency legislative sessions. You will see attorneys general filing appeals and requesting stays, but given the unanimous margin, many of those efforts will fail. New York residents could soon see Subway and Times Square carry bans blocked by federal courts. Californians will likely regain the ability to carry in parks, parking lots, and many public spaces previously off limits. Illinois gun owners are watching the waiting period evaporate in real time. The bigger philosophical shift this ruling represents is perhaps its most lasting legacy. For decades, the gun control movement operated under a public health model, treating firearms like cigarettes or dangerous pharmaceuticals to be regulated heavily through taxes, licensing, licensing, fees, and restrictions until ownership became rare and difficult. The Supreme Court has now drawn a clear and unmistakable line. The Second Amendment is a civil right, not a public health privilege. It sits alongside freedom of speech and protection from unreasonable searches. You cannot require a permit to speak. You cannot charge a fee to vote. And now you cannot demand expensive training, subjective approval, or lengthy waiting periods just to exercise the right to bear arms outside the home. This is the great unwinding of a century of precedent. The battle is not ending. It is evolving and moving to new battlegrounds. Local ordinances, civil liability mechanisms, expanded dangerous person definitions, ammunition regulations, and insurance requirements. The cat-and-mouse game between lawmakers and the Constitution continues, and every new regulation will face the same fundamental question that now defines this entire era of legal conflict. Does it respect the Constitution, or does it burden a constitutional right? That question will define the next decade. This ruling is not the final chapter of the Second Amendment debate. It is the opening of an entirely new one. The rules of engagement have changed. The legal standards are different. And the consequences will be felt for years to come by ordinary Americans in every part of this country, regardless of where they stand on the underlying policy questions. So here's what I want you to honestly answer in the comments right now. After hearing everything, the specific laws that are falling, the human stories on both sides, the genuine legal uncertainty ahead, do you believe this makes America safer, less safe, or does it ultimately make no meaningful difference at all? I am not looking for a political performance. I want your genuine gut reaction after hearing the full picture. Are you a single parent in a high-crime neighborhood who finally feels empowered? A law enforcement officer concerned about untrained carriers? A constitutionalist who believes an armed society is a polite society? A parent who worries about more guns in more public spaces? Drop your answer below. This conversation is bigger than politics. It is bigger than headlines. It is about how constitutional rights should actually function in a modern society. And that debate, after this 9-0 ruling, may only just be beginning. There's also a dimension to this ruling that connects to the broader legal landscape in ways that will surprise many people. The same week this Second Amendment decision dropped, the court issued another 9-0 ruling in a separate case involving commercial liability. Legal observers immediately identified a parallel logic running through both decisions, the idea that long-standing legal immunities can be re-examined when the constitutional foundation beneath them shifts. Some scholars are already asking whether that reasoning could eventually apply to the Protection of Lawful Commerce in Arms Act, the federal law shielding gun manufacturers from any lawsuits involving downstream misuse of their products. The battlefield keeps moving, and it moves in directions nobody fully predicts. What is certain is this. The panic in those 19 state capitals is completely justified. They just lost the legal foundation built over more than a century in one unanimous decision. For gun owners who have waited decades for this moment, it feels like a historic restoration of rights long denied. For others, it feels like the opening of Pandora's box with consequences that cannot be fully anticipated. Wherever you stand, the legal landscape of American gun rights will never return to what it was before this ruling. And the story is moving fast. Lower courts are already flooded with challenges. Injunctions are being filed by the hour. Emergency legislative sessions are being scheduled. Every development matters. And the people watching most closely right now are not the ones making the loudest noise. They are the attorneys, the constitutional scholars, and the everyday Americans quietly calculating what their rights actually mean in the city, town, or neighborhood where they live. Stay informed, stay engaged, and keep watching closely, because the next major legal battle may already be taking shape. And when it arrives, it could be even larger than the ruling that put all 19 states on alert in the first place.